call this meeting to order. This is a subcommittee where we'll be looking at HOAs, aka Homeowners Association. So, excuse me, I'm catching my breath. Was running up here. There's a little traffic out there today with the rain, so I know we've got a few members that are probably delayed from that, and I know one of our speakers is as well. So, Chairman Dixon, will you lead us in a word of prayer to get us started here? Was that two?
If you would bow your heads. Dear Heavenly Father, I pray for a hedge of protection around our country, around our schools, our school children, given the horrific events that happened just a few weeks ago in my district in Barrow County. Lord, I pray that you lift those families up. I also pray that you grant this board wisdom, the subcommittee wisdom, as we go through HOAs and seeing what some of the difficulties are surrounding HOAs and if there's any needed changes, Lord. In your Heavenly Father's name, amen.
Amen, and thank you. Okay, so first I want to kind of talk about the purpose of this. And so in coming up with the purpose, really, in saying what it's not is just as important as saying what it is. We aren't putting this together to go out and try to ban HOAs. So anybody that sees HOAs as a good tool for doing good things for their community, it's like all tools. All tools can be good. Some tools can be bad. So we are going to be looking for the good things that are done, and we're going to be looking at the bad things that are done, and then we are going to figure out where we as a state, where can we help in alleviating some of these issues, finding solutions. So as you're, for the public who wants to testify, and if you're not on the specific agenda, there is a sign up, and we have that, and there should be ample time for everyone to be heard. And I certainly do want to hear from as many people that want to speak. So anyway, with that being said, that is really kind of the purpose of this. Again, we're not out to get anybody. We're just trying to hear from everybody and then figure out what we can do as a state to help find solutions. And that is the purpose and the only purpose. And we are set up as very similar to a study committee. And so we are simply studying this issue, and then we will be working across party lines to figure out what exactly do we need to do, what exactly can we do. Okay, with that, I do have Chairman Dixon is serving on this committee with us. Chairman Dixon is he is our chairman of Education and Youth Committee here in the Senate. And Chairman Dixon, you want to introduce yourself real quick?
Absolutely, Mr. Chairman. Thank you. Yes, my name is Clint Dixon. I represent the 45th Senate District, which covers the northern portions of Gwinnett and about 50% of Barrow County, ranging from Auburn to Winder. I've been in the Senate, was elected in 2020, so ending my second term, going into my third term. My first 2 years was one of the governor's floor leaders, and the past 2 years have served as chairman of Education and Youth. But in my day job, I'm a dirt guy, real estate guy by trade, acquisition development for new home communities. So familiar on the new home side, the developer side of HOAs, and then transitioning those over to the homeowners. And at one time, had a lapse in judgment and was HOA president for 2 years, and it was probably the most difficult job that I ever had. So with that, Mr. Chairman, thank you for letting me introduce myself.
Thank you for that. And my name is Matt Brass. I'm from Noonan, Georgia, down in Coweta County. I represent all of Coweta County, all of Heard County, parts of Fulton, and parts of Douglas. And the new district, should I win, I'll be coming out of Douglas and Fulton, and I'll have all of Heard, all of Coweta, and about half of Carroll County. So I live in a part of the state that is growing rapidly, and we have neighborhoods going up left and right, and I just want to make sure we're getting this right. So I am in my 8th year and currently serve as the rules chairman. I have served as the banking chairman and as the redistricting chairman as well. So, and I think all our other committee members are not going to introduce themselves today. So let's get rolling. All right. Amanda Dutton, are you with us? Oh, there you are. I'm sorry. Amanda, would you like to come up to the podium? Amanda is a researcher on HOA abuse and legislative reform. The podium would be best. Yes. Just please a brief introduction of yourself, and then you can just jump right in.
All right. Thank you very much. I appreciate the opportunity to be here. I'm an independent researcher on the topic of HOAs and HOA abuse. I'm an advocate for homeowners, and I have started a company and website in which I provide information and professional lectures on different topics to educate the public with regard to how they can strengthen themselves, how they can fight for themselves, what the rules are, how to have a balanced and fair, challenge to any sort of problems that they have. I'm happy to hand out my card to anybody that would like it. And I'm also wanting to write a book, and I'm collecting testimonies. So if you have a horror story to tell, I'm open to hearing it, and again, I just want to help. I don't charge anything for what I do to homeowners, so if there's anything I can do to help or people I can put you in contact with, I'm happy to do that, so what little I can do, right? But yes, thank you so much. Again, yes, I am Dr. Amanda M. Dutton, and I wish to thank Senator Brass and the members of the subcommittee for giving me the opportunity to speak today. As this committee has already determined, some homeowner associations present a clear and present danger to millions of homeowners in the state of Georgia and across the nation. After countless hours of research and after hearing endless accounts of horror after horror that people suffer at the hands of HOA boards, their very neighbors, the most concise statement I can make in regard to HOA legislation is that homeowners need legal, actionable, and accessible protection from HOA abuse. The statement provided by Senator Brass with regard to the committee absolutely captures the essence of the need which it will address, in that it will, quote, ensure these entities comply with state law and uphold residents' constitutional rights. Their power cannot be limitless, end quote. Ultimately, any individual who is given power over other persons must have a mechanism of oversight and accountability to check and balance that power. When considering legislation, every loophole must be closed, every possibility for abuse must be considered and precluded, and yes, even those possibilities that you would think, you would dismiss because you think someone would never do that, I assure you they will. And even if you say legally they can't, they likely still will, because currently there are no consequences or accountability for bad actors. They can hide behind teams of lawyers and their insurance company, both of which have explored every corner of the law and have excised what can impede them. As esteemed expert on HOAs, Dr. Evan McKenzie states in his book, Privatopia, quote, advocates have been successful in preventing the courts and legislature from treating common interest developments, which most often form HOAs, as either private government or businesses, leaving them with a special, unregulated status, end quote. In many cases, they have simply written their own laws within HOA governing documents to sidestep protections and rights that most Americans believe are unalienable. If someone lives in an HOA, they absolutely have been alienated from their rights as Americans. These bad actors don't follow the rules if they don't want to, because they don't have to. There's absolutely nothing but their own goodwill and sense of what's right that will stop them, and that is only if they have it. And when they don't have that sense of right, they really don't have it, and the rest of us are our subjects and victims. Such legislation would retroactively create this balancing of power and creation of protection for all homeowner citizens, which would consist of two things: a reduction of the excessive power of HOAs and an increase in homeowner protections. I have additional information to these points in the provided handout. The most crucial aspects reform legislation could contain is provision that HOA board members must be held accountable and responsible to an actual government authority which can render judgment and have the authority to enforce compliance against wrongdoers. And HOA boards should be unable to destroy residents' finances or take their homes. In detail, what is needed to balance the power of HOAs over homeowners are 8 points, which are as follows. Board power should be limited to reasonable fee or fine amounts which will not destroy a resident's financial existence, with no power to lien or foreclose a home. Any instance in which enforcement is needed in the case of a negligent or nuisance resident should be addressed in cooperation with the governing agencies, such as code enforcement. The power of HOA boards to levy fines must be restricted to reasonable limits, which cannot be aggregated and compiled in a manner designed to bring financial ruin upon an individual resident. This should include the inability for HOAs to fine contesting residents their attorney fees. That is, they should adhere to the American rule and should be denied the ability to circumvent it and their governing documents. HOA abuse and crime must no longer be considered a private or civil matter. Law enforcement and other government officials must be given the power to enforce citizen rights, or it should be ensured that they act to enforce those rights and protect citizens if they already have those powers. The overseeing authority must be freely and financially accessible to everyday citizens so that all persons can be fairly heard and justice and enforcement can be rendered equally. Assurances of legal protection must be retroactive upon all existing contracts or agreements regardless of age. There need to be legal consequences for individual bad actors enforced by actual government authority outside of private lawsuits for abusive or illegal behavior. The rights of American citizens granted by the 14th Amendment of the United States Constitution, along with many others, must be ensured by systematic and periodic review of individual associations' governing documents to ensure, and if needed enforce, compliance with all federal and state laws and citizen protections. In keeping with the practice of HOAs being registered as corporations with the Secretary of State, they must be held accountable as corporations to all laws, requirements, and codes of conduct and ethics that all other corporations are bound to. They must not be able to dodge accountability by claiming private entity status. Currently, the HOA Reform and Homeowner Rights Advocacy Group Hurling recommends that a division of the Attorney General's Office be created and empowered to oversee and regulate HOA boards and their members, just as they do any other business, so that home buyers, as consumers, have the protection they desperately need. Complete suggestions and further details in this regard can be found on the Hurling website at hoareformleaders.com. In this way, HOAs can be regulated and overseen just as any other business with real consequences that will hold bad actors in check and prevent the rampant and outrageous abuse that many HOA residents suffer. Personal accountability and responsibility paired with limiting of power are the only way to curb abusive and criminal behavior and must legally be put in place and enforceable by the law. Otherwise, it will be, and in many cases currently is, completely ignored. No American citizen should have to suffer the fear and terror of being left financially decimated and destitute for fighting for what are normally their rights as an American citizen, especially over what many times amounts to a pool membership. Prioritizing and enacting legislation which creates these protections will do much to correct the power imbalance, to return American rights to American citizens, and to create a fair and balanced system that is agreeable to both homeowner residents and those HOAs that act responsibly and fairly. Homeowners need you, actual, fairly elected, duly appointed, qualified members of the leadership of our state and nation to step up and bring these associations into line with the rest of America, with justice and liberty, with checks and balances, with accountability and consequences. Anything less abandons us to the evils that America itself was created to defy. I humbly submit these recommendations with gratitude for your work to fight for those citizens who are otherwise completely helpless and at the mercy of a system which knows none. I remain always at your service. Thank you.
All right, thank you, Dr. Dutton. We got a couple arrivals here. I've got my, if y'all would be ready for a quick introduction of yourselves. You're good real quick. So our vice chairman of this subcommittee is going to be Senator Donzella James, who took a deep dive into this last year. And so I invited her, and she is now serving as an ex officio on the Rules Committee so that I could put her on this because we needed her knowledge, institutional knowledge on this. So, Senator James, if you quick introduction of yourself.
Hello, good morning, everyone. I'm Donzella James, Senator currently for the 35th District, but next year I'll be the 28th District. But I want to represent all of Georgia, no matter where you live in 159 counties. So thank you, and thank you for allowing me to be a part of this committee.
Absolutely. Glad to have you. All right. And we have our distinguished minority leader, Gloria Butler.
Thank you, Mr. Chairman, and good morning to everyone. I think we need to do a study committee on traffic. But I'm pleased to be here. Thank you, Mr. Chairman, for asking me to serve as ex officio because I think homeowners association across Georgia have some issues, as mine as well. I live in a subdivision that has HOA, and they're just coming out with some new rules. Sounds like another committee board that we've been dealing with for the last few weeks, gaining what they conceive as their power to do whatever they want. But we see it other ways, and there are other ways to do things besides putting people in distress when they're on their own homes. Thank you, Mr. Chairman.
Absolutely. All right, Senator Rep out of Marietta.
That's from Marietta, Georgia. Glad to have this opportunity for us to come together and discuss this topic. I'm sure we'll come up with some good ideas to make life a lot more pleasant down on Primrose Lane, because life's a holiday on Primrose Lane. Thank you so much. That's a generational thing. Some people got it, some people didn't.
I don't think anybody got it. I'm just messing with you. All right, for y'all that just came in, Dr. Dutton just presented, but she had a sheet for us in your folders. So let's see, I did have, and this is, I appreciate what you did here, Dr. Dutton. You bring solutions, and one question I do have is, do you know other states that you feel like are getting it right that we could be looking at, or is there specific laws within each state that we need to be looking at?
Yeah, it's a very sticky situation. I'm sure you're very familiar with what's been happening in Florida since they passed HB 919, which calls HOAs into account. It's in reaction to the Surfside collapse, the condominium that collapsed a couple years ago. But the problem is that it wasn't being maintained properly, and that's what caused it to happen. So they passed the legislation in order to require HOA boards, COA boards to specifically for condos there, but also other areas, homes and so forth, to make sure that they were up to date to code and safety concerns. And that just caused them, and because a lot of them don't have reserve funds, to require special assessments that are forcing elderly people, well, everybody, but especially retirees and elderly people with with limited income, out of their homes. And when they sell those homes, they take the special assessment fees, and so these people have to sell their homes and are left with next to nothing sometimes. And so they have no home, no finances, no equity. I can provide a more thorough examination of what HB 919 did at your request, and I can give you the good, the bad, and the ugly, and the unknown at this point, because it is something that Governor DeSantis is dealing with to try to ameliorate the issues that came of that. So, for instance, grandfathering, special loans, things like that. But for what it did is it actually called them to account. And so the HOAs and the COAs that were doing well and had good reserves and had been up to date on maintenance, they're fine. But the ones that did not, they're suddenly scrambling. So Florida is a very interesting scenario right now because we can look at it and say, okay, this didn't quite work that well. How do we do the same thing in a different manner that is more agreeable to everybody? So yes, they have the most forward changes, and I think every state has something going on. I don't have it memorized, I'm afraid, but I can also provide information if you like through my group of advocacy colleagues who have that information.
Okay. Any questions, other questions from the committee? Sure, Senator James.
Thank you very much, Doctor, for coming and sharing this good information. But aren't there other states that have been working with HOAs that's changed a lot of things other than Florida?
Yes, they're all working on different bills. They have different approaches. A lot of times it's more of the piecemeal approach, which seems to work because you can more easily reach compromise in that respect, right? So however you wish to approach it, we can see that Florida did a complete overhaul, and then there's other states who are doing a little here, a little there, and in between. So it is an interesting thing. Unfortunately, I have a full-time job with my full-time hobby. So it's hard to keep up sometimes when I'm teaching. However, I can provide that information upon request if you would like to have recent bills that were passed in all 50 states.
Well, specifically, I wanted to look at the one issue of, for example, Georgia giving liens against people's property for not just for being late, but for grass too high, shutters painted black and it's not in the covenant, things like that. And then they continue to add fines of $100 sometime a week until you can get it repaired or changed. You have no way to protest it. You have to do it. So I wanted to know and then they can sell your house on the courthouse steps without even your knowledge. You know you've been getting liens. Because if you didn't satisfy them, they can do that and sell your house and purchase it, really. So I wanted to know what we could do to stop or put some kind of regulations on that particular part of this issue.
Currently, there are, I believe it's 9, don't quote me directly on that, states that do forbid foreclosure. Yes.
Wow. Thank you.
And also some have higher numbers for the lien accrual, and also judicial review. That is a big thing in Georgia. It does not have to go under judicial review. So if it is something where this is an abusive situation, somebody's taking advantage or targeting people, which is a huge problem, pyramid fees, all that, it doesn't go under judicial review in order to say, yes, they are in the right in order to initiate this foreclosure or these liens, and it just happens and people are left homeless with no recourse, especially if you have no income. People are being told that their rights as Americans are not financially worth fighting for. It costs at least $15,000 to step into court with an attorney. It's $5,000 to have an attorney just look at your case to do a discovery. I'm a teacher. Thank you, by the way. You guys have helped us out a whole lot with our income recently. I sincerely appreciate that. But I can't afford a $30,000 lawsuit. And if I lose my lawsuit, or even if I win, my group can charge me their attorney's fees. I have to budget $60,000, which is my salary, and I have very little income. Savings. I have income, but very little savings. How is a normal person supposed to fight this? And also, again, against an association that is abusing their power.
Yes.
We have to spend that much money for our rights? And that's all of us. That's all of us everywhere. Every single person in this room. No matter who you are.
Is there a specific issue that happened to you that got you so passionate about this?
I do have boy, it is a long story.
No, I don't want the long
No,
version.
no. I don't want it either, neither does anyone. It is a group who is acting against the Georgia POAA Act. They are forcing people to be part of a pool membership when, contrary to the POA Act by definition and applicability, if you are subsumed under that act and have an association, all homes in the neighborhood need to be part of that group, and 25% of the homes in my neighborhood are not part of it. They also are violating their own bylaws because they're supposed to offer levels of membership, and they said, no, we're not doing that anymore. Everybody, as soon as you sign on, you buy a house, and if it's not part of the group, as soon as you sign on, you and anyone who buys your house from then forward ad infinitum must be part of that group. And if somebody previously has joined, of course, you are stuck, even if you don't want to. But if I bought the house next door that's not part of it, it makes no sense. And there's many other violations, questions about accounting, all kinds of things. It's abusive behavior. If you speak up, you're silenced. They won't listen to you at meetings, that sort of thing.
Okay. Question, Senator Dixon.
Thank you, Mr. Chairman. Just wanted to kind of dive into the, as far as the pyramid fees
Yes,
or the
sir.
accruals from attorneys. I understand that can become very burdensome and become into the tens of thousands of dollars that, you spoke of, individuals losing their home.
Mm-hmm.
And then also, how long is the process once a lien is filed to when somebody would potentially have their house sold on the courthouse steps because of that?
Yeah, it's. I'm actually sure and I know that there are people in the room here who can speak to that experience, and my heart goes to you. As soon as they can get the process going, if they say your pin is wrong, I'm sorry, it's off on your lapel, $50 every day until you fix it. And of course, that comes in the mail, so that's 3 days delay. And then you fix it, then you have to pay your charges. That goes through the mail. It starts accruing. Then the attorney writes you a letter saying, whatever correspondence they need to have. They charge you for that fee, and it just builds and builds and builds. And I was just talking to a gentleman who said that the association refused to take his dues payment, and then started charging fees because he wasn't. It makes no sense. So I do not know the exact time frame. I can find that out for you. However, as soon as they can rack that up to $2,000, they can start the process.
So that is the threshold at $2,000?
$2,000 in the state of Georgia is the threshold to foreclose, and that could be justified lien or justified fees or not. They put the lien on your house, and as soon as it's $2,000, they can take your home, and they don't have to tell you. There are stories of people who someone knocks on the door and says, hey, this is my house, get out. And they bought it for pennies on the dollar.
Okay, great. Okay.
And they lose all of their equity, everything. And sometimes it's the HOA people who are doing that, forcing the people out of the house. They buy the house on the courthouse steps and then flip it for their profit. How is this possible? Thank
All
you.
right, Senator Rhett.
So you're saying that there's no mechanism to let people know that their house is getting ready to be sold so that they can reconcile that?
Nope. Not if they choose not to, and it's probably in the paperwork, it's probably in the books, but they don't follow it because there's no means of accountability, so they do not have to.
Also,
Nobody holds them to it.
is there some sort of a uniform method to determine the amount of fees charged by the different homeowner associations? Or is it uniform, or is it arbitrary?
They make it up as they go. It actually says in the governing documents I have, we can charge you any fee at our discretion for whatever they decide is inappropriate. And they will say, they can determine if it's 25, 50, 100, if it's every day, if it's, every week that you're late. They make their own rules. And they're not bound by anybody to have a fair system or anything like that. They just make their own rules, and if they decide to change it, sometimes they don't even hold votes or meetings, and they just start changing things, and people are hit with these sudden things that they did not even know about. I was never given governing documents at our closing. I had no idea what we were getting into.
Did you talk with your attorney about that? Your closing attorney?
Yeah, they said they would write a demand letter, but that's all they could do.
That sounds off.
Can I say one thing?
Sure.
Again, I thank you very much, but I wanted to just add that we had several hearings on this issue, and at my very first hearing, we had some widows or people who were had sold their house. They lived in Buckhead all these years in big houses, and since they were alone now, they had moved, and they were still in the area in a condominium. They had purchased. One lady, for example, said her next door neighbor had just had liens put on her. She had paid over $1 million for that condominium, and for the $2,000 worth of liens, they took her. I get all choked up and thinking this is why I'm so passionate about it.
Yes, ma'am.
I found out from the beginning that it's enormous fees. You could have a house for $200,000 or a house for over $1 million, and just $2,000 worth of liens could take this woman's property. And she passed away after that. It's just heart problems. She couldn't believe that, you know, she was a widow, her kids were gone too, and she lost her place. So that's why I'm fighting hard for this. Thank you for bringing this good information.
Yes, ma'am. You actually bring up a very good point. A lot of times people are targeted because they are older, because they are part of a minority community, because anything. Because they said, hey, please don't let your dog pee in my grass, something like that. And they are targeted by these people for their religion, for anything. And of course, as soon as somebody needs help, that's when they get torn down. And they're eradicated by that system because they are undesirable.
Thank you.
Thank you, Dr. Dutton.
Thank you,
Appreciate
sir.
all your comments.
Chance to speak. Thank you.
Absolutely. Okay, next up, we've got David Dreyer. David was actually supposed to go first, but got caught in a little traffic. So.
I did.
So-
Thank you for accommodating me.
Absolutely. Appreciate you being here.
No.
No, you bring a level of expertise that that we need for this committee. So if you
No,
would
thank-
just introduce yourself and get rolling.
Thank you, Chairman.
Yes, sir.
And
Glad to
thank-
have you.
Thank you, Senators. Thank you, staff members, for taking a look at this issue. It's very important. It's actually a very good segue. So I'm a practicing litigator, right? And I just had a jury trial in July in DeKalb County. I ran up against an issue where one predatory developer would target 1970s, 1980s era condominiums. The individual would start buying condominiums, each under a separate LLC, so that this individual could take over the HOA board. Once they took over the HOA board, they would jack prices up. They would fine people arbitrarily, and they would refuse to correctly apply payments and foreclose as fast as possible. This individual had already done this on 3 other condos in Tucker and converted them from condominiums to apartments. Once you get 80% of them, you can flip them to apartments. So you're really removing one of the only affordable home ownership mechanisms left in the metro area, older condominiums. Okay, so I do get paid for my work. We were able to do this efficiently, but I represented 3 individuals that were investors. They had between 1 to 4 condominiums in this condominium unit. They had the misfortune of getting on the HOA board prior to this predatory individual coming in. The HOA board was vacant. The other people had resigned. There was problems, water liens from Tucker, things that needed to be done better. Our folks stood up, said, okay, we'll take on this. They didn't know somebody had already begun acquiring large portions of the condominiums in this. So then that individual took over the HOA board, appointed himself as CEO, and sued the past board because he needed their condominium units to get to the 80% threshold. So we were in litigation for 4 years, had to go all the way through a jury trial. Fortunately, these individuals could pay 50% of my fees, because I did feel pretty strongly that we could win in a jury trial. And, you know, we were defendants in DeKalb County. We had to explain complicated HOA law, but the jury really got this and they understood what was going on. But we were sitting there even then waiting on a group of people that we hope we had educated fully on what happened to come back in. The jury took it incredibly seriously. They actually stayed until 12:30 a.m. After 4 days of trial to come in and give us that jury verdict. And they did award indemnification. They awarded attorney's fees. But the individual that had been trying to get all these condominiums and that had been leading the lawsuit, as soon as he was blocked and he had run up HOA fees, legal fees, is trying to sell all his condominium units in a block right now. And I want to tell you, it's because I'd started this case about 5 years ago before prices have increased kind of across the board. I was charging $350 an hour. I continued that rate all the way through trial. The attorneys that I beat at trial were charging $895 an hour because no one was paying. Nobody individually was paying these individuals. It was the HOA that was paying. And then when we got a judgment for $110,000, they said, well, we can't pay you right now. We'll have to do a special assessment. So we will collect, but it was just incredibly fortunate that these three individuals could afford legal services. I mean, I knew they were going to be able to pay me one way or another, but I remember thinking, I hate to lose, but I remember thinking at the end of that it would have just been unjust if we would have lost that jury trial. Unfortunately, we were successful. And this is a complicated issue, so I really appreciate the work and digging in this, because it means a whole lot to a lot of people.
Okay, we got any questions from the committee? Senator James, I'm sure you got some.
I'm sorry. Well, I thank you very much. I was going to call you representative,
Right.
but you're still my representative.
Thank you. Thank you.
But I know that this happens a lot, and you're one of the few people who I've heard that won a case. Also, you're one of the very few attorneys that I know that will even take these kind of cases. So I applaud you, and I want to know what we need to do to get, since we have these cases all over the state, what we could possibly do to get more attorneys to look at the issue and not just how much money they'll make or not make.
I know. Senator, I'd be candid. I can't advertise HOA law, that I do HOA law, because so many people would not be able to afford the representation on this.
Right.
And it does bother me. If there was just a methods of accountability for the people that have abusive practices, and I don't know what those are. I haven't studied those, but I told the chairman that I had a particular experience in this one. But you're right. The DeKalb County clerk does a great job. But when our judgment went down to be entered, they inadvertently put the HOA as the creditor and my clients as the debtor, because they had never seen it the other way. Never. So some way to level that playing field would mean a lot.
One last thing, I know that many of the people who are having the problems, who are the victims of all of this, go before, they have to go to court. They have to pay the same lawyer of their HOA that their dues have been paying for. Mm-hmm. And one lady had paid for a house 10 years before that. She was just paying HOA fees and had never missed. But she got some liens because of some of the things they didn't like. I think she said she put a fountain on the side of her yard, a pretty fountain. Everybody in the neighborhood said they loved it, but it wasn't in the HOA. So she ended up paying $250,000 just to, and she still had to take her fountain down. And they wouldn't even let her put it in her backyard. So, you know, believe me, this is very serious. Thank you for your testimony, and I look forward to talking to you privately.
Thank you.
What level court were you in? Was it
Superior Court, DeKalb Superior
or
Court.
was Superior Court? Okay.
Yeah.
Senator Rett?
Thank you, Mr. Chairman. Is there a threshold when an HOA can force a foreclosure on a property? How low can the liens be before they initiate a foreclosure?
It's a good question. Senator, I didn't deal with a foreclosure in this process, but it's extremely low. I think 2,000, right? And on this one, just again, because these individuals here had the resources to hire an attorney, I went through their HOA charges and payments, and when I first looked at it, I was like, I can't show this to a jury. It shows all these late fees. They're like, no, they were all paid on time. They weren't credited. And I was able to actually get the accounting to prove that in court. But that's a very expensive process for me to prove to a jury. I mean, when I have to introduce an email, I have to have a subpoena sent to someone, they have to sign an affidavit, and then it's a business record, and that's just one email to introduce to a jury. And when you're talking about stacks of documents and accounting on a PowerPoint, it's incredibly expensive and an intense process for that.
Thank you.
Thank you.
All right, Chairman Dixon.
I just curious, 'cause you're speaking about the case, it was a condominium. Are you seeing that same issue like in single family or townhomes where it's fee simple ownership, or is it more in the condo type ownership?
I'm seeing it in townhomes too.
Okay.
I am seeing it in townhomes. You know, I mean, we see around here neighborhoods owned by investment funds sometimes, right? I do see some similar targeting on townhome HOAs, and sometimes trying to use the HOA as, often using the HOA as an unlevel playing field to acquire the remaining units. And then they would all be rentals at that point.
Yeah, I've heard of that big push, the build for rent, or the for rent, you know, it being, you know, Wall Street money coming in and buying up complete subdivisions and whatnot. So, okay, so you're seeing it there as well.
Exactly, Senator. But what we're seeing is somebody will find a townhome HOA with 60 units, and then they'll be able to start acquiring enough that they can take control of the HOA. And then they'll use the powers of the HOA to get the remaining units. So it's more of a copy of the Wall Street model to build it, but it's more predatory in my mind.
Thank you.
Thank you.
Any other questions for Mr. Dreyer? In full disclosure, Mr. Dreyer did serve 6 years in the State
years.
House. He came in with me in 2017,
I
and
did.
he wised up before the rest of us did. So,
I stood right here very nervous, holding a piece of legislation a few times.
yeah.
But I, you know, the great thing about Georgia is we've had wise leaders that were willing to work across the aisle and find good solutions, and that's why we are far and away better than our neighboring states in many cases. And so really thank you for continuing that tradition.
Absolutely. All right. Well, thank you very much. Okay. Next up, we've got Mr. Robert Carswell from Coweta County. How you doing, Robert?
Good morning, Senator Bryce,
Good.
distinguished members of the subcommittee. Hello, my name is Robert Carswell, and I want to give a mild bit of background. First off, I'm an educated civil engineer, and I've worked in that field for a little while, also accounting as well. I have degrees in that as well. I'm an academic working at Georgia Tech, so I come from that background. As far as HOAs, I have lived in a few HOA committee neighborhoods. I have Had the unfortunate pleasure of serving on a committee, both in a secretarial role, a treasurer role, and unfortunately a president role. I did so not on purpose. I didn't intend to ever get involved. It all started one day. I was walking in my neighborhood, and a very old man whose wife had cancer was sitting at his mailbox painting it. And he was doing so because he had a fine, one of those $25 a day fines, because his mailbox was slightly faded. And that's not how we treat our elderly. It's not how we treat our neighbors. And that's just not the right way to do things. And it bothered me. It bothered me as a person. It bothered me as a Christian. It bothered me as a Boy Scout, as a community member, as all sorts of things. And I walked down to the meeting, and I stuck my foot in something I probably shouldn't have. And I started getting involved. And that was the kind of person I brought to it. And ultimately what resulted is I brought that kind of spirit to the HOA when I served on it. And it led me to ultimately being targeted. And in my targeting, I faced a lot of prejudiceness. I faced a lot of attacks, and it resulted in my family having to leave the community. It resulted in a legal action against me that I did beat. It resulted in a lawsuit that I did win, but I did so because I had resources. I had money, and it was a lot of money that I had to put up that we were able to do. Luckily for me, my wife is an attorney, and she had friends that she was able to reach out to. We had contacts we were able to reach out to. We had the ability to move very quickly. I had to take my kids out of their neighborhood, out of their bedrooms, out of their backyard where they loved to play, and move them to a new house. And this was a long process. And we survived, and we're beyond it now. But I survived because I was privileged. And that's a privilege that most people do not have. And it is unfortunate that that was the experience I had, because I barely survived it. And I'm here, I reached out to Senator Brass because we can do better. HOAs are not an evil, they're a tool. But sometimes they need a little help, and that's what I'm hoping that y'all can do. That's what I'm hoping that we can do here. These are micro governments. They're tiny little fiefdoms, and if you have a good king, a good president, a good leader, someone who cares, they're wonderful parts of the community. They bring people together. They do beautiful things at the pool. They do beautiful fall festivals. They welcome people to the community and tell them where things are and help them be part of something. If you have an evil king, they're torturous. They discriminate. They isolate people. They steal their resources, their blood, sweat, and tears. And they have no accountability. And we have many examples of how this happens. There's the fines that happen day after day because of a little thing like a faded mailbox. That's not how neighbors treat people. Yes, grass grows. Sometimes you have something happen, your lawnmower breaks or whatever. One of the things we tried to do on our HOA that I advocated for, we have a landscaping company. Our landscaping company does both commercial and private entities. He is more than capable of cutting the front yard of somebody's house, and he could do it for about $45. A fine should never be more than he could cut their front yard for, and he can do it in about 15 minutes. When you have a house that has a $450 to $500 fine for a front yard of high grass, we have failed as a community, and yet we would have that. And when I advocated no, I pissed off the wrong people, and they targeted me. We had issues in our neighborhood with street parking, and we actually interacted with our attorney on this, and our attorney explained to us that in Georgia, there's no actual conclusion on this, that it's vague. No one's actually made a decision. Now, our covenant specifically says that the street is right away open to the public and that we have no jurisdiction on it in our covenants. The state, or I'm sorry, the county that we live in, our sheriff's department and police chief have also said that same thing, that the streets are public property and the HOA has no jurisdiction on it. But it has never come before the court, and our attorney said that. She's told us that the people you fine for street parking are the ones who don't fight it. Fine them, don't fine the people who will fight it, because you don't want it to go to court, because you don't want a ruling. And these are opportunities that y'all could give, to give clarification on certain rules, to give people a way to do an oversight, an ombudsman type process, like a committee or something that we could go to. And places that can do that, or some of these HOAs, collect fees. Charge some of these bigger HOAs a 1% fee to pay for it. Let them pay for the process so that these community members can go and say, we have a problem, give us a level playing field. Let us negotiate and be better off so it doesn't have to go to court. Because not everybody can open their checkbook. Not everybody can call their wife and go, I needed a problem, or I need an attorney now. And their wife can't call up their friends in their phone book and go, hey, Attorney Taylor, come down here and help us right now. And they can't drop it and come to me when I'm standing in handcuffs and I need it right then. That's my experience. And I was lucky. My neighbors might not be that lucky.
Robert, I want to go back to the street parking on the roads. Who in that particular neighborhood, was the HOA responsible for the paving of the roads, or was it the county?
The HOA is not
city?
responsible for paving the roads on the public streets. It's the county. The HOA does have private alleyways, and in the case of the private alleyways, absolutely the HOA does have jurisdiction. However, for the private alleyways, they're also so small that even if it was a public street, it would follow the Georgia laws for public alleyways. You wouldn't have been able to park on them anyways. They're too small anyways.
Okay.
And which again, our wonderful police chief and had told us that for Coweta County, or I'm sorry, the city of Noonan. And the police department doesn't want to deal with that because they know it's neighborhood squabbles. And so there are legitimate things the police should be doing about parking on a street. They're truly unsafe ways to park on a street. You shouldn't park at a stop sign. You shouldn't park in front of a fire hydrant. You shouldn't park in front of somebody's driveway. But there are very safe ways to do. In fact, like I said, I work at Georgia Tech. My civil engineering degree is focused on transportation. There's numerous very good researched academic studies that talk about street parking being well done and well marked. It actually slows down and makes neighborhoods safer if it's correctly done. If it's incorrectly done, it makes things really dangerous. But if you have nothing and it's the Wild West, it makes it even more dangerous. And when you have no oversight, no clear rules that say yes or no, and like I said, our attorney in our community physically said, right now it's a vague area and nobody's come out and said one way or another. And to be fair, even if the state physically came out and said in HOA communities, no street parking, that at least says no. And that means that they can't play a fun game of will we, want we, where we can use this to harass citizens.
Okay. Any other questions from the committee? Senator Dixon.
And even in that instance, if the state, if legislation was passed, no street parking in HOAs or allowing it, it would still be, the governance would still fall to the local police department or the sheriff's department. It wouldn't be the HOA, and we need some
Absolutely.
definition there.
And it would be clear.
Because I had a constituent actually reach out to me that heard about the subcommittee that you created, and thank you for doing that. I didn't thank you when we got started, but and they're not in a gated community; it's public streets, and she's only been in the house since March and already has liens on her house because of street parking alone, and it's a public street. So and that's in a single family, detached community. So.
HOAs derive a lot of their ability to harass people from that shadow area. They hide the covenants. I believe it was mentioned that the covenants wasn't given to them when they first came in. One of the things I did when I became the secretary is I digitized our covenants. I converted it into a searchable PDF, and I put it online, which was not something that we had done. We had already gotten this kind of paper-copied version that was really hard to search. Well, I made it a searchable PDF, so if you had a question about something, a basketball goal, a flower pot, a paint color, it's a PDF now. Search it. And the number of people that pissed off because you could search for the answer really upset. It was amazing how many people that upset, because anytime somebody asked me a question in a meeting, I was like, oh, you can go to the website now and search our entire covenants. And when you give information to the public, it shouldn't upset anybody. It should be seen as a help. And so these covenants should be public record. The budget should be public record. We should be able to see, even before you move into a community, what these budgets are doing, what these covenants are doing, what these minutes are doing. Y'all are held to these same standards. We can see what y'all's minutes are. We can see what y'all's budgets are. An HOA should not be above y'all.
Good point. Any further questions?
No, I have to say something.
Come on, sister.
Sir, I truly thank you for being here today. You mentioned a lot of things that we found out from past hearings that we've had, and we didn't act on them, and maybe we can act on some of them now. One, of course, I want to first say we're not against homeowners associations, condominium associations, trailer park associations, et cetera, et cetera. We're fighting the predatory ones. And you're right, there's so many that do great things. And so I've even been in one before. So, I participated as you did. When you act interested about something, next thing you know, you're an officer.
I could feel your passion in the room.
Yeah. So that's one thing. But I did put in legislation for Osbusman office, and about maybe 1% of each homeowner would pay, and it would cover that. It would go under Department of Community Affairs. It would be in there, a person where homeowners who do not have the money to pay for or to ask the questions of an attorney or someone can go there and find out if they have a case, what they need to do, etc. And also that Osbusman committee, office rather, could do other things too, could be there for the homeowners. So they are paying for it. The second thing is parking.
Senator James, real quick.
Real quick.
If we're going to, let's not talk about solutions yet. Let's just, we're already running over time.
Okay,
so
I was bringing it up because
I want to
of the
make
parking.
sure everybody gets a chance to be heard that showed up today. So let's hold off on solutions, because that's going to be down the road.
Can I
So,
make a quick point about parking?
sure.
Okay, my point is that some of the people who were complaining because they got tickets for the parking, and then they got the HOA, they didn't even know the people. They were visiting someone else and could not get into that person's driveway. So, but they still were responsible. So that's something too that we need to look at. Thank you.
I thank y'all for y'all's
Thank you.
service on this. And if there's anything I can do to serve more on this, provide y'all any expertise I can.
Thank you.
Thank
y'all for
you.
your
Thank
time.
you, Robert. And in the spirit of full transparency, Robert's wife and my mother-in-law serve as attorneys together in the same practice. And so when he mentioned Attorney Taylor, that's my mother-in-law. But I don't think he called her. All right. Next up, we've got LaTanya Hollis, a homeowner in Cobb and Fulton. You live in both?
Yes.
Wow. Just a, you summer in Fulton and winter in Cobb?
No, when I work too late, I'm in Fulton.
Gotcha.
Good morning, distinguished members of the Georgia Senate and Subcommittee. I first would like to say thank you, especially to Senator Brass, for formulating this committee, and thank you for all your service to this great state. My name is LaTanya Hollis, and I am a constituent in the 5th District represented by Nikema Williams. Thank you for allowing me to speak today and share my story and my observations. Esteemed members of the Georgia Subcommittee, I come before you today to discuss a pressing issue that is profoundly affecting homeowners throughout our state. After meeting with several attorneys regarding my own case, I have uncovered some deeply concerning trends in the way homeowners associations operate. And mind you, each time that you interview an attorney, their minimum fees could be anywhere from $250 to $350 just for a consultation. Attorneys have expressed throughout Georgia their dismay at the almost autonomous power that HOAs wield when it comes to enforcing covenants and restrictions, even to the point that many attorneys are not accepting cases because they believe that most attorneys are stating that the courts will always rule in the favor of the HOA. These regulations are often written in a biased manner that favors the HOA, leaving homeowners with little recourse. The prevailing sentiment is that cases are typically ruled in favor of the HOA, which undermines the rights of homeowners. One alarming practice is that once a lien is placed on a property and legal representation is involved, HOAs actively lock out homeowners out of their financial accounts. This prevents them from viewing their balance and paying any outstanding fees, further complicating the situation. In gated communities, the situation can become even more dire. HOAs have the authority to prevent homeowners from entering into their own homes once a lien has been established. This level of control is not only excessive, but raises serious concerns about property rights. Moreover, some HOAs hire private investigators without the homeowner's consent to surveil residents in an effort to support their claims in rental property disputes. This intrusive practice not only infringes on privacy, but also highlights the lengths to which some HOAs will go to enforce their rules. Minor infractions such as overgrown weeds or unpaid fees as low as 10% of an annual balance can lead to severe consequences. HOAs can remove homeowners' names from call boxes, effectively barring them from entering into their properties. In some cases, HOAs representatives have even shown up at residents' doors to investigate who is living in the home, acting more like pseudo-security officers than a governing body. The financial burden this imposes on homeowners is staggering. Each year, thousands of Georgia families are losing their homes, not due to an inability to pay their mortgages or their HOA dues, but because they are overwhelmed by fines for minor infractions. The cost associated with hiring legal counsel, coupled with HOA fees and daily interest charges, can quickly become insurmountable. There is a clear need for reform to protect homeowners' rights and ensure accountability and create a more equitable system for community governance for homeowners. Currently, in many Atlanta neighborhoods, HOAs have restricted access into their gated communities in which they own a home simply for delinquent dues. Homeowners are being denied through the main gates, including the HOA implementing policies that remove their names from call boxes. This coercive collection tactic effectively traps the homeowners outside of their community until they have settled their accounts, causing significant stress and inconvenience. Once a lien is placed on a homeowner's property, that homeowner is subject to pay that lien in addition to applied daily interest, attorney's fees from HOA securing legal action, penalties, charges, plus the outstanding balance of the HOA dues for owing less than 10% of their annual HOA dues. As you can imagine, these fees on top of annual property taxes and their monthly homeowners insurance payments and a mortgage payment can be a heavy burden. HOAs can foreclose on a property for liens as low as $2,000, forcing a sale to a new owner, even in instances where a home still has a mortgage. Homeowners can face unjust treatment when HOAs impose substantial fees and penalties, potentially leading to the loss of their homes. This often occurs when HOAs misuse their authority, applying excessive charges for minor violations and relatively small overdue accounts. The Office of Consumer Protection reports receiving a significant number of complaints related to HOAs, particularly concerning unfair practices, excessive fines, and failure to follow proper procedures. I'll go into what happened to me about 14 years ago when I was married. I received a $5,000 threat of a fine for claiming that I was renting my property. And what had occurred was the fact that they didn't recognize my husband. So they automatically assumed without any due diligence that I was not renting my property. I had to send in a copy of my marriage certificate to the HOA in order to convince them that I was not renting my property. Another issue that happened to me recently was the fact that I had a faded mailbox. I received a letter in the mail that stated that mailbox needed to be painted. I travel out of the country often for work. I live part-time in Portugal. So, of course, sometimes I'm out of the country for as long as 3 to 6 months. And, of course, in the summer, we all know this Georgia heat, mailbox can be faded. I was threatened with a $500 fine for not having the right shade of black. I'll describe the most recent currently situation that has happened is the fact that what brought me here today is the fact that the HOA in my Fulton County property has placed a $21,000 lien against my my second home in Fulton County, claiming that I'm renting the property, stating that I am leasing my property. I own this property free and clear. I've owned it since 2008. I don't owe a mortgage on it. I bought it back in 2010 after the housing crisis. And the reason why it's my second home is because I actually work downtown Atlanta. I work 12-hour days, and sometimes when I'm exhausted, I will go and stay. My daughter and I will stay at the property on those late evenings. So I interviewed several attorneys to fight this lien, and that's when I became aware that attorneys, many Georgia attorneys, are not even accepting cases because they believe the majority of the time that the HOAs have so much autonomous power that they won't even take your case. As a result of that, I've spent over $2,000 in just interviewing attorneys to accept my case. And the gentleman before me described privilege. I am able to pay these fees simply because of privilege. But how many homeowners are losing their homes because they can't afford to pay these enormous fees? My vision and my goal for my daughter is to leave this home to her so that no matter what happens to her in life, because I'm an old mom, I had her when I was 42. And so I don't know if I'll be around in my 60s or 70s. I hope I am, but I want to make sure that I leave her with a legacy, that no matter what she goes through in life, she will always have a home. And even if she only has to pay the $500 a month HOA fee, she will always be able to call something her own without being having to pay a mortgage. But that gift can be taken away if I can't fight this $21,000 lien plus $8,279.35 in attorney's fees that the HOA has placed in addition to the $21,000 lien that has been placed against my property. When I first moved into my home in Vinings, I received a letter in the mail for a threat of a $350 fine for my Cobb County home back in 2007. And that letter read that my pine straw in my yard was not fluffy enough. It didn't read that the pine straw needed to be replaced. It didn't read that the pine straw was faded. Till this day, I still keep a copy of that letter just to remind me every day how much power HOAs wield by the fact that they sent me a letter communicating that my pine straw was not fluffy enough. In conclusion, I would like to say homeowners associations in Atlanta, Georgia wield the legal power to foreclose on properties for unpaid dues, creating a minefield for homeowners. This authority opens the door to significant challenges as homeowners find themselves burdened with crippling legal fees, both for having to obtain legal counsel to represent them, delinquent charges and fees, penalties paid for delinquent past due, and additional fees added to the delinquent balance with the HOA refers to the homeowner association attorney. As a result of this lien, I am currently locked out of my McGill Park home. I cannot access the property. The HOA has advised that the only way I can access the property is through a walking gate because they have jurisdiction over the front gate entrance to the community. My property sits right across from a busy state, from the Georgia Power facility. In order for me to be able to get to that property, I would have to cross a busy street. I emailed the HOA and addressed my concerns. My daughter, who has some medical issues, I explained to them that we have her medicine bag is in that property, and they stated that if I wanted to access the property, I would have to access it through the walking gate, which means I would have to walk up 3 blocks because we all know how the lack of parking there is in downtown Atlanta. I would have to walk 3 blocks and attempt to cross the street in order to access that property through the gate to be able to gain access to her medical bag. More insidiously, this power can be exploited by corrupt board members who engage in predatory practice, making false claims to harass homeowners or drive them out of the community. These bad actors thrive on disputes, leveraging the fear of foreclosure to inflict undue stress and harm on individuals simply seeking to maintain their homes. The potential for abuse creates a hostile environment where homeowners are left vulnerable to intimidation and manipulation, all under the guise of community governance. Thank you.
Thank you. Any quick questions? Okay, thank you very much. I am too. All right, just for committee members, you got her comments, and there's some court cases and very good examples of things. And just so you know, gonna have Senate research look at all these and we'll look at some of the rulings and get some of the, you know, I know one of them, they ruled in favor of the HOA based on ambiguous language. So we want to take a look at that and see what that judge was referencing. And those are the types of holes in the law that we need to be looking for. Just FYI. All right. Let's see. Next up, we've got, Jessica Navas signed up, but I believe, there you are here. Come on up, Jessica, and we're on the podium here. Y'all can come up together. We've got a lot of folks signed up, so just try to keep comments to about 5 minutes.
Okay.
You know, I know I've seen your presentation.
Can I sit closer to y'all and not in the corner, or is this better?
You're gonna be on TV there. You can come here and you won't be seen.
Oh, okay.
You will be heard, but it'll be harder to see.
All right,
you.
sounds good, I'll stay here.
Okay.
Well, first of all, and my wife agreed to let me speak for both of us. So, first of all, thank you.
How'd you get her to do that?
I don't get her to do anything.
I need some lessons from you.
So, first of all, I want to thank you all. I know that there's a lot of frustration that is brought forward from my fellow homeowners who are here with this topic, and these are the people who are stepping up for you. These are the people you need to come to, and these are the people, Senator Brass, you were the first person to hear us. Friday night at like 8 o'clock, I think, he heard our HOA and our toxic HOA issues, so thank you again. And of course, Senator Donzella James has been carrying the banner, and everyone. Just for brevity, I won't mention everyone, so forgive me for that. So my name's David Bazone. This is my wife, Jessica Navas. I can't show you my presentation, but we will see about sending her what we can do. So the first thing that I was going to show in my presentation is with regards to what the gentleman spoke to. When you, I want to dispel a myth, which is that we say HOA and we think levity, that it's not serious matter, that it's not. But what we're talking about now, just to put a different term on it, is HOA law. And like you said, Senator, you all are trying to close that gap that exists in legal power. So the problem is that power corrupts, and absolute power corrupts absolutely. If I wanted to, and this is an example, if I wanted to make a complaint against one of the senators, there is a process for doing that. In Georgia, for Georgians, for homeowners, for local property owners, there is no recourse at this moment aside from death by fees for attorneys, and even then, good luck. So the first thing I was going to show, I've had the same experience as the gentleman. My exes, as I call them, the ex-board that we were called, the ex-attorneys that we fired, the ex-management company that we also fired, when the people of Belmont Park stood up as homeowners in a way that they had not done in 20 years, we said, no longer. And I was proud to give them that voice. It's not us, because behind us there are 118 homeowners that you do not see here. This is a death threat. It has, I'll just describe it to you. It's a postcard. It says The Hearse, which I think is a movie from the 80s. Someone else can correct me. It's not my generation. It says, the barrier between life and death is no greater than the thickness of a door, and now the door is open. And it has a ghostly woman and a hearse with an open door. And I'll read the other part of the postcard. We brought this to the inspector, the postal inspector, so just to save you time, they did not take action on that. We brought it to the Noonan Police Department. They did not take action on that. We brought it to the FBI. They have not taken action on this. So it says, go, and I won't cuss, but I'll leave it to your imagination. Go yourselves, you pathetic pieces of shame on you, seriously, off. And it says HOA losers, and has our address at Noonan, Georgia. So when people get in these positions of power, and there are loopholes that they can exploit all day long, they become drunk with power, and that's what we've seen. So I'm going to move on from that. Senator Brass, I think one of the things, and I'm not going into solutions, but that you mentioned in an interview that would be a key issue is the suppression of voting rights, because it's the foundation for our democracy, right? And so why would homeowners not be able to vote when normally in other places they can? This is the first thing that toxic HOAs go after. They are able to generate a lack of voting rights, an inability for suffrage. Because if they give you a fine, and this has happened in our HOA at Belmont Park for 20 years, where they told us, they sent an official letter, and I can't display it, where they said that if you have any fines, any late fees, any missed dues, then you cannot vote. But they're the ones who give the late fees, right? They're the ones who give the fines. They're the ones who process the dues. And in many cases, we had homeowners whose dues were not processed properly, in my opinion. So that would be a key issue. I want to bring
Robert,
up...
real quick on that point.
David.
I'm sorry, David.
No worries.
Robert was up earlier. I'm getting confused.
A lot of people.
David, earlier this year during session, it was kind of in the last hour, we actually did a floor amendment to do away with that, or at least attempted to, but again, it was kind of in the late hours of our last night. So we've already taken a stab at it, and that is one thing we're looking at to make sure we got right, because nobody's losing their voting rights.
Thank you.
In a HOA.
Thank you. Our constitutional rights. Thank you for defending the Constitution. So the next part, so I have for what I call the 3 layers of HOA hell, and I have to bring my voice down to say that, is normally what you see brought up. So there's one toxic board, right? You have a toxic board, they're abusive, they go after you, they don't follow covenants properly, they don't have to report to anyone. They're toxic, in my opinion. And all of this is my opinion, by the way. Number 2 is what we've seen grown around, that has grown around these loopholes, which is industry professionals, and I wanted to thank the, I believe, attorney and representative who was here earlier, who have, in my opinion, strayed from what I would call a straight path. in their occupation and have seen ways to benefit or to seek benefit that sacrifice the rights of homeowners. So I wanted to mention some specific examples quickly. So we that would be management companies. Normally, it's a burgeoning, growing industry, and then HOA attorneys as well. Our particular management companies, our first one after we gave them HOA help right back, they left. They actually dissolved their LLC and were out of the picture. But what they did was, in my understanding, based on evidence, sold their portfolio, which was us, to another bigger, badder management company, right? So what we see happening under the management company, we did a recall. Everything was legal. We had an attorney present. We followed the covenants to remove our, in my opinion, toxic HOA board. And what the management company did was back the board. And I personally believe it was because it was in their best interests to do so as a business entity. So Century Management Incorporated backed our board. I can't show you this letter, but they state the Belmont Park Homeowners Association is writing to homeowners to inform them that there was a change in the association board of directors, and the notice of special meeting, I'm going to paraphrase, given by the petitioners, which was us, the actual homeowners of Belmont Park, is canceled. So they told us that although we had gotten an overwhelming majority of signatures from the neighborhood, the management company came in and backed the old board and said that effort is invalid. We are canceling your meeting that you called according to Georgia law and according to your covenants. So I'm going to move on. So let's talk about the HOA attorneys that were involved in our case. And again,
David, real quick, you
Yes,
got
sir.
about 3 minutes.
3 minutes. I'll skate through. I won't walk. Thank you. And I appreciate a timekeeper because I tend to ramble. So the HOA attorneys, I can't show you this, but when we fired our attorneys, which was the Dunlap Gardner law firm, we were not satisfied because they did not give us their collections accounts. So they had collection accounts. Our neighborhood had more liens. To the gentleman's question on liens, we had more liens than we had houses. We had upwards of between 150, 200, correct, liens, and we only have 118 houses. That means multiple liens on houses. We discovered that there were liens, and these are HOA liens, there were HOA liens that had carried over from previous home ownership. And you say, how can that happen? It should not be happening. So when this happened, we fired them, Dunlap Gardner. We voted as a board, duly elected, and so they resigned. But what they did was this. So the attorney, I'll paraphrase, but he'll know what I'm talking about, is they did what's called a substitute of counsel. This is open record. You can look in the Coweta court system to see. A substitute of counsel is intended for someone to change your attorney. But what was done was another prominent, especially related to HOA issues, firm called Litigation Johansson. We received an email as the board of the duly elected board of directors of Belmont Park received a CC'd email between Dunlap Gardner, HOA attorneys or collection attorneys, if you listen to their voicemail, and Litigation Johansson, where they say, the letter you received dated 1 week ago, just when I was, a previous letter, on November 27th, should be ignored. It was written by, they put Rouge, I think they meant to say the rogue resident group within the community that, as I understand it, has no authority to act on behalf of the corporation, which is the HOA. And they're requesting records. They're very interested in transfer to our firm, including all collection files, also include a current report on the status of collection accounts, and et cetera, attorney's fees, statements, open collection accounts. So they're very interested in the collections accounts, the liens that are open on our neighborhood. And you know that if they were to decide to, they could have come in to, for lack of a better phrase, cash in on the neighborhood that has more liens than it has homeowners and houses. So Lisagan Johansson, I don't know their intentions, and I'm not trying to state what they were, but they came in, Dunlap and Garner did a substitute of counsel to make them our HOA attorneys. This is without our board voting for them to be our attorneys, without the neighborhood voting to be our attorneys. So I'm going to move on.
David, do y'all have, so when you say y'all took over, when did this happen?
October 15th, 2023 is our independence.
Okay, so it was after we met.
Yes, sir.
Yeah, okay. So y'all have control of the board now, the homeowners?
We have been able to return control of the board to the homeowners, yes, sir.
Okay.
After what has seemed like a lifetime and what I would call fortuitous, miraculous intervention. A recall is not easy to do, sir. I just want to make sure that's clear.
No, I've got you. I mean, I was taken back by the meeting we had about a year ago. So.
And you saw that firsthand.
Which is what led us to here. So, okay, well, for sake of time, David and Jessica, thank y'all both for being here.
Mm-hmm.
If you would, send your presentation to, you've got Mercedes' email, you've got mine, just send it to both of us and we will distribute it to the committee.
Okay.
If there's anything else you'd like to add that you weren't, able to cover, simply you can add that as well. We'll distribute it to the committee and it'll be part of the record. So, okay?
We appreciate the time.
All right, thank y'all very much.
Thank you.
All right, Karen Bremer. The recently retired.
Oh, my.
Yeah, everybody keeps saying, really, you're retired? Hi, good morning, Mr. Chairman and esteemed senators. It's so wonderful to see y'all again. And it's very interesting to be on this side and what I'm going to talk about today. As you said, I'm retired. I'm a former chief executive of a statewide not-for-profit organization. I was a small business owner. I have been the president of 2 HOAs in the city of Atlanta, one in Inman Park, one in Virginia Highlands, and I'm currently a commissioner of planning and zoning in the town of Turin in Coweta County. I am a resident of Coweta County in a subdivision called Grayson Farms in the town of Turin. We are off of State Road 16 and Highway 54.
In full disclosure, real quick, Karen, they all reached out to me. I didn't reach out to them this wasn't a, attack. They all reached out to me with issues, and so I invited them here to be here.
Right.
So thank you for being here, Karen.
And I thank you for the opportunity to speak today. Absolutely. And I have some specific issues that I would like to address that are conveyed to certain homeowners association relationships in Georgia that y'all might not be aware of. And that is the responsibility of the developer and the local governments to their homeowners in the HOA and their citizens to follow their own ordinances and their own contracts that they have entered into with developers. 2 years ago, my husband and I purchased a home in Grayson Farms subdivision located on Lynch Road in Turin, Georgia. The subdivision was developed by a developer who's very well known in Coweta County, Todd Freeman, and our home was built by a company called New Leaf Construction. Prior to purchasing our home, I reviewed the HOA covenants, which appeared reasonable to me and seemed to provide necessary protection for our new retirement home. Previously, we lived in rural Fayette County in an agricultural district and had a very large piece of property with no HOA and no covenants. Okay. I also researched the subdivision and land development ordinances, and I also reviewed the annexation agreement between the developer, Todd Freeman, and the town of Turin. Additionally, at that point, I learned that there was a subdivision improvement guarantee maintenance bond in place. At the time of our purchase, Grayson Farms was approximately 80% complete. We have roughly 100 homes in our subdivision, And prior to our subdivision, the population of this town was 250. We're a population of 500 now. So basically, we are the voting bloc. And we have successfully elected one of our residents to be on the town council in our town. So shortly after we moved in, Todd Freeman, through a property management company called Homeowners, based in Coweta County, announced that he was transferring control of the HOA to the residents and would no longer serve as the declarant. Before an HOA board is formed by the residents, the person in charge is the declarant of that, and it's usually the developer. HomeLink, which had been managing the subdivision on behalf of Todd Freeman, sent a notice to the community requesting a meeting to form a board of directors. Our residents assembled. We elected a 5-person board of directors consisting of president, vice president, treasurer, secretary, and member at large. For full transparency, my husband, John Piazza, was elected president. I worked with the board on, and I worked with my husband on helping to create an orientation for these board members and a review of all the covenants and any surrounding legislation that would affect them. I am not involved with that board. However, I wanted to make sure they start out on firm ground. I've run many boards, national, state, local, and I know how important a representative board structure is to the success of any organization, as well as the orientation of people to that board of directors. So anyhow, upon the election, we discovered we were able to review finally the financial statements. We couldn't review them before the budget, and we discovered that the HOA had no reserves and had numerous outstanding invoices. Additionally, several issues with common areas remained incomplete and unfunded. So our board members and concerned residents started attending the Town of Turin council meetings, and we made numerous public comments regarding these issues. And after a few months, we found out that our comments were not even being recorded in the town minutes, which I know is not legal. And so I became a very strong, passionate advocate and pointed out all the laws that they were breaking at that time in terms of open meetings, meetings records, transparency. I think that's when they realized I knew what I was talking about. And to date, they've been included. Then on February 26th of this year, a town council meeting was held, and a motion was passed unanimously by the town council to exercise the maintenance bond against the developer. However, to date, the mayor of Turin has not acted on the vote of town council, leaving the residents of Grayson Farms facing repair costs in the hundreds of thousands of dollars. I have documents that I have presented to Mercedes that I will send, we will send electronically, and basically they're issues concerning retention and detention bonds. The property is roughly over 100 acres. We have 7 retention ponds, and we have certain drainage easements. They were never maintained. They were not properly put in, and we currently have issues with drainage easements. I have 6 neighbors that have something that's resembling a miniature Grand Canyon now going through their properties, and their fences are about to go into that. It's going to damage their homes. We have sidewalks. We have a sidewalk, a main sidewalk on the main road, Lynch Road, coming into Turin there, where there's a culvert that was not repaired properly, and it is about to sink along with the sidewalk. It is the sidewalk that's on the main street that everybody walks along. And all of these items that I'm talking to you about are required in the annexation agreement and in the ordinances that declare what the responsibilities are when you are building, what you are supposed to build. The one issue that I find particularly interesting is when our home was built, there was a strip of asphalt put in front of our house while the building was going on. Assumed I was going to get a road there. Well, it comes to find out they're not putting a road there. So I have a 15-foot piece of asphalt in front of a $600,000 home with $700,000 homes on either side of us that they say they don't have to put a street in. But according to the law in the town of Turin, there has to be a road there. This strip of asphalt is 15 feet across. In the state of Georgia, an alley has to be at least 16 feet, and a street has to be at least 24 feet. It's also also supposed to have street lights, sidewalks, and curbs. There are numerous other issues. The least of, there's actually an ordinance that requires what sort of landscaping needs to be done in the neighborhood. Nobody has done any of that. I had a discussion with our town engineer recently, Brennan Jones, and I asked him about the approvals on all of these issues, which is in the documents there. And he was the one that signed off on the completion. And I asked him how much liability insurance he had. Did he have good errors and omissions insurance? And he said, "Oh, it's not my problem. It's the town's problem. They're the one that signed off on it." And we have realized at this point that we need to hire an attorney to sue the town, as there's no legal recourse in the state of Georgia to hold a municipality accountable to ensure that their own ordinances are followed. And we at this point are sort of aghast at what we need to do. We're going to have to convene meetings, probably assess fairly significant assessments. The one repair of the sidewalk and the culvert is over $100,000. And so that's $1,000. In our neighborhood, they're nicer homes, but probably 10% of our neighborhood is law enforcement officials, our teachers. There's a group of retirees, such as me and my husband. And we're the type of neighborhood, and our HOA, sure, we have a company that will tell you your grass is too long, but we go to our neighbors and we say to them, "Hey, we notice you haven't cut your grass. What's the matter?" "Oh, well, my husband's sick." "Well, let's come over. We'll take care of mowing your grass for you." Issues like that we talk about. And if somebody doesn't listen, well, yeah, the management company is going to send them a note. And on that note, in Magistrates Court in Coweta County, we've never had a judge give payment for the fines, only for what was due in terms of dues and things like that. And, you know, I don't know what can be done about this, but this is not a nice story of people that were following the law, read all of this, and in Georgia, when you join an HOA, it is required by law that you receive a copy of this in your closing documents, and you have to sign that you have received this in your closing documents. So I just hope when y'all are looking at solutions that you also look at solutions that will hold developers accountable and will hold municipal governments accountable to what is even in their own ordinances and rules. So, any questions?
No questions? We got one over there.
Well, more of a statement. One thing I would check, and the municipality may not have required, most of them require when the ponds are put in, a maintenance bond that's put up by the developer, and then also a performance bond with the streets. I would check. I mean, they may not have
we have
required
that.
it.
We have that. The mayor of the town refuses to take action. We had a unanimous vote.
He could call that bond and pull that money.
We know that. We know that. And he's told us he's going to call it, but he hasn't called it. And he tries to avoid coming to town council meetings. So, and just keeps brushing over it. The attorney keeps brushing it over. I think they're waiting for it to run out. My impression is there is a personal relationship between these folks and
Karen,
the developer.
let's not.
So,
let's not go
anyhow,
there.
personal opinion.
Okay.
Thank you.
Thank you. All right, next up I've got Nicole Reeves. You're with from Walton Hill.
Good morning, panel. My name is Nicole Reeves. Most of you guys may know me because I frequently email you guys maybe once or twice every month or so in regards to my HOA. I just want to kind of piggyback off what everybody says about the lack of accountability. I live in a small working class community in the city of South Fulton, and most of us who live in these communities don't have the funds or the means to pay for lawyers. I myself have been kind of fortunate enough to be able to do so, but I've had a lawyer to demand budgetary items for my HOA. They refused to give me anything in regards to the budget. We don't have any we don't have any common areas. We don't have a pool, a tennis court, a clubhouse, and they're spending an exorbitant amount of funds in my community. And I started to inquire about where the funds are going, and then that's when the harassment started, arbitrary fines, and in certain economic situations, community members are afraid of these people because they don't have the means or just the education to be ordered in order to stand up and against them and fight against them. So there is a very, very great need for HOA reform. As far as like somebody mentioned previously about you guys have more oversight when it comes to budget and fiduciary responsibilities, more so than people who typically don't have a background in accounting or any means of running a board or any kind of as it relates to accounting and money. So just for like homeowners like myself who live in certain types of communities, we need more help than anybody. Thank you.
Thank you, Nicole. More questions?
Can I ask a question?
Yeah, sure, Nicole, if you'll answer one question.
Thank you. I live in the city of South Fulton and helped create it. Where do you?
So I'm one of Linda Pritchard's constituents. So she's the city councilman for my district of the city of Old National Corridor. Yes, ma'am.
Right. Well, okay.
Because I've come to one of your meetings before. We had one on Old National. Yes,
But
ma'am.
You didn't speak, did you?
I didn't speak, not at that particular, but
She's speaking now.
It's getting to the point where it's becoming very unbearable. And then sometimes, when you're harassed, it takes a toll on your mental, your financial. And like this lady over here, I'm also a school teacher, so I took time out today to come down here to speak to you guys because I feel that this is a very important matter that needs to be addressed. A lot of us in my neighborhood, do have liens and do have foreclosures on their homes, and they don't have the financial means to kind of fight there or even to get a lawyer. So I'm just speaking up for the underdog. I mean, we need somebody who's willing to fight, and I just happen to be that person in our neighborhood. So like in my neighborhood, I put out newsletters. I go from house to house to try to garner up participation, but people are afraid. They are afraid, and so somebody has to fight. And
Well, please
okay, yes,
get with me because I've been your senator for years.
So
and years.
like I said, I
And
know
so-
I've
but
emailed
not now.
you. I've emailed you, Senator James,
Yeah.
Brass. Like I said, once every week. Like so, they try to
I
use
remember you
intimidation to kind of shut people up. But it's like either you fight and you still get picked on. If you don't fight, you still get picked on. So I just choose to fight in the battle. So that's my stance for right now. So
I'll be happy to talk to you and bring the new senator, and we see what we can do.
okay, yes, ma'am. Looking forward to
Support
it.
the efforts that this committee hopefully will be
Okay.
able to do. Thank you.
Okay, thank you.
Thank you, Ms. Reeves.
Thank you.
All right, James Gear. How you doing, Mr. Gear?
I'm good. My name is James Gear, and I own a townhome in Cobb County, Georgia. I thank the committee for letting me share my situation or experiences on townhome ownership. In March 2023, my townhome association placed a charge on my account. There was no prior communication to me. I labored for 3 months to get the board or the management company to provide me an explanation of why this had been done. It took 6 months before a voluntary compliance letter was provided to me. At no time had the board or any of its agents ever provided a, quote, fine letter as required by our governing documents to the association. The board and their agents simply ignored communications to them which challenged their actions. Rather than responding with clarification for their actions or trying to resolve the matter, the association and their agents began a series of retaliation efforts in order to collect what I learned to be a $412.99 fine for damages to an asset that the association did not own. The association and their board, their agents, did the following. First, they cut off access to the community website, which prevented me from paying online. Refused to respond to my safety issue questions and a bylaws change information request. They refused to accept the January 2004 dues payment, for which there was no dispute, and returned it 3 times without communication or explaining their actions. They put my account out for collection, filed a lien on my property, including the funds they refused to accept but had in their hands, threatened foreclosure over a $412 home to my community sell for $550,000. The association and board found time to authorize the above actions, but in 18 months, not one board member has taken 5 minutes to respond to my communications. In May of 2024, I filed legal action against the association. I have to do it myself. I could not find a lawyer. The association stated in their answer, and I quote, "Defendant admits that its March 2015-2023 letter, not provided to me until September of 2023, did not contain all provisions required by the association's governing documents." Then, without notice or communication, the lien was removed. The most concerning part of this is the association and their agents were able to file an intentionally false lien stating I owed more than $3,000 without any court appearance or challenge. In this case, the association used their refusing to process funds received to add late fees and interest, thereby just jacking up. I now assume it's to get over that $2,000 limit. I have owned this property since 2008, and I've always paid my dues on time and in full. While my court case continues, here's what I would recommend the Committee for Changes to Georgia law. Make it illegal for an association to foreclose on a property without a court hearing. Require a court judgment before an association can file a lien on a property. Make it illegal for an association to refuse to accept payments for amounts that are not in dispute. Require associations to provide credit to fees if services provided by those fees are suspended or frozen. Require the association or its agents to update the owner monthly, including with the most recent account statement on the status of its claim against the owner, and provide a description and a reason for any new actions taken by them. Well, I could go on about other association experiences. The major issue always comes down to communication. Associations and their management companies should be required to communicate with owners, especially when it comes to liens and foreclosures. Thank you.
Thank you, Mr. Gear. No questions. Okay. Is it? Yeah. Would you mind sharing your statement? Did you have it written down?
I do have copies.
Yeah. Full. Do you have it? Okay. If she has it, we will distribute to the committee. All right. Elaine Sanders. Probably not saying that right. Is it Elaine?
You said it right.
Oh, yeah.
Good morning.
I get an A for the day. Good morning, Miss Sanders. How are you?
I'm fine. How are you doing?
And where are you from?
I am from Stone Mountain, Georgia.
Okay.
And I'm here to get clarification on HB 220 with respect to the voting rights. I know that you all, I know it's in law, but I don't understand. I need clarification, let's put it like that. I just need clarification when a voting right can be denied or privileges, with amenities. I didn't quite understand the law, so.
Okay, we'll get you some information. We've got your, is it UE Sanders?
Correct.
At yahoo.com? Okay, we will get you that information. We'll get you a summary of the bill and what it does.
Okay. Well, I have a summary of the bill. I've read it several times. I just don't understand.
What's your specific question?
If there are some points where it says that, in one sentence, that you cannot, a board cannot deny a person voting privileges simply for a fine. But then it's like generic, but then it says voting can't deny them for, if you have an outstanding fine, cannot deny a person to vote for a board. So there's more than one vote. So is it just for a board, or is it voting in totality? And then as far as fines, if you have an outstanding fine, can they deny you your privileges of using, amenities, or is that simply when you don't pay assessment? They're all in there, and it was just unclear,
Welcome
what
to
the law
government.
is saying.
Let me, I haven't looked at the bill in a long time, so let us look at it and dig into it.
Okay.
And like I stated earlier, we kind of did this on the last day, really. And so let me go back and we'll get you a more detailed summary of what exactly we did. And again, I did state earlier, we're going to revisit this anyway and see what, we miss stuff all the time. And so it did pass. I know it passed.
It did pass,
Her
yes.
specific question, was it related to voting on board members or voting on all the issues that come before the HOA? So if I remember correctly, I do think it was specific to voting for the elections.
Elections only.
Yeah, I do think it was specific to that. But again, that is one thing we can look at as far as the voting rights go.
Okay.
So
Thank you.
thank you. Okay, next up, Karen Thomas. Are you still with us? There you are. How you doing?
I am well, sir. How are you?
Great.
To the Senate Committee, I appreciate the opportunity to come before you. My name is Karen Thomas. I live in the city of Morrow. The community property is Woodstone South Condominium Association. I bought in 2018. Okay. The community was developed in 1972. So it's an older community. They're conjoined townhome units. We pay $220 per month, zero amenities, and if you calculate that, that's $26,000 a month, $322,000 per year that is being collected. I've only received 2 board meeting notices since 2018, and after the 2023 receiving, I do have the budgets for the first quarter of 2023, which does not jive with the proposed budget for 2024. After buying, in 2023, after that board notice, I started getting involved in the community a lot more, doing newsletters, etc. In March 2023, I received my 3rd cease and desist from the attorneys who felt like I was presenting myself as a board member by being active in the community. May 2023, I emailed the management company, which happens to be the same management company as Mr. Bazone and Ms. Navis, that'd be Century Management, which involves the same attorneys, which would be Dunlap and Gardner. And the response I got back from the management company regarding the roads was that we don't know who owns the roads. So you're telling me since 1972 you've never done road repairs. A simple email to the county. The county explained that, and this is Clayton County, if the community's developer did not dedicate the roads to the county or to the city, then we're a private community and we're responsible for our own roads. Nothing has been done to the roads, and since then, you get ignored, pretty much to piggyback like everyone else said. The consensus is we don't have to talk to you. We don't have to respond to you. And that is pretty much what you get. So, March 30, 2024 board meeting notice. We received the board meeting notice for a meeting scheduled March 30th, 2024. However, if you check the Secretary of State website, the board has already installed itself as of March 19. So you've installed yourself, and you have been consistently installing yourself prior to my arrival in 2018. So since 2010, you have been consistently registering yourself as the board. The CEO does not live in the community. She owns 1 unit. The CFO is 92 years old, totally incapacitated, resides in the community, and owns 8 units. The secretary doesn't reside in the community, never seen her before, and she owns 4 units. The corporate address for her regarding her properties leads to an empty building. The at-large member also doesn't reside in the community. I've never seen that person before either. So we have 4 board members. Only 1 lives in the community, and he's 92 years old, totally oblivious to even board meetings taking place. So I thought that was a form of elder abuse to totally just install this man who has no knowledge that he's being installed. So after doing a consensus of the property owners, I found that 30 of those properties are owned by LLCs. LLCs are so easy to create. A lot of times these LLCs lead to out-of-state addresses, or the LLC will lead back to the property address for which they don't reside. The tenant resides there. So there's this large network of creating LLCs, buying up properties. You have this incredible challenge of trying to determine who are these people, where do they live, how are they able to so easily take over your community. And the reason why is because the board doesn't feel like they have to monitor anyone. When I began to establish the newspaper and I went into the portal, much like everyone says, they lock you out of the portal. They transition you into a system of payment. When I go into the portal, it completely says not accepting payment. They have shut down payment abilities to the extent where I walked into MoneyGram to send them a payment. Shut out. I attempted to send you from my bank account an ACH transaction. It processed, you accepted it, and then you turned around and deposited it back into my account. So, as the consensus is, there's this air of we don't have to unless you take us to court. What I did learn is Georgia is a non-judicial state, which means anything and everything involving the board and their power, you have to take it to court. And in this community, we are one of those communities, Clayton County being a Tier 1 county, meaning that, of course, they're on the lower scale of anything. And then the community is a very nice community. We work. It's low income on some levels, but these are 1-bedrooms to 5-bedroom units. We have developers or investors like Fair Offer Atlanta, who does come in, refurbish these units, and then they put them for sale so we can gain more ownership, owner occupied, so that we can work together. But the minute you stand up, like everyone said, you are a target. I've had a lien placed on my property for $1,700. I'm hearing the threshold is $2,000. Mine was $1,700. I filed Chapter 13, canceled it. So going forward, I'm still dealing with the same issues. I'm still dealing with the same attorneys. They don't want to respond. The board member won't respond. You never see the board members. And then you have these community individuals who, if somebody don't tell you, you won't know. If somebody don't say, hey, we have covenants, we have rules. Like I said, these are 1972. No additional amendments to bring us up to date of where we are as the community changes. And so the rules and regulations are from 2001. But when I say, hey, can we get these updated? It's too expensive. So you think it's too expensive to update the bylaws, but we can't get roads. You're forced to pave the public access road by the city that leads into the community. After that, they're bad. The roads are bad, and we need help. And I recall Senator James came to all the meetings, I believe, last year when she mentioned the ombudsman. There's also an article in a paper from Bibb County where Bibb County, and I had mentioned receivership before. And receivership is, of course, when you go into the Superior Court and you ask the judge, hey, I need somebody to help us take over this community until we can get to a place of solvency and we can fix ourselves. The only reason why the effort failed was that when the community in Bibb County went to Superior Court agreed with the community, we're going to shift you over up under this attorney. The appeals court, however, says you can't do this only because you did not properly notify all of the owners. So I've always felt that receivership was a good avenue that can be taken, but again, we're talking about court costs and money and fees, and we just don't have them. So we need you to have our backs on this, please.
Okay, thank you. Ms. Thomas, any questions? I think we're good. Thank you very much. Okay, I don't have anybody else signed up. I know we had a couple late arrivals. Anybody that did not have the opportunity to sign up, I'm going to give you, you got 2 minutes. So I saw the gentleman in the back raise your hand. Did you come on up? Another gentleman.
I'll try to make this a very quick 2 minutes.
That'd be great.
Yep. So my name is Michael Shepard. I previously attended meetings on the issues of HOAs. I currently own an investment property in the city of Atlanta in Fulton County. As soon as I bought this property, my intention was to provide additional affordable housing. That's a very salient issue. My goal was to fix up, dilapidated property to code, to standard, and potentially provide that to someone on housing choice voucher. I quickly learned that this community had several issues, and it was basically stemming all from the HOA. I continually call them a cartel HOA. It sounds slanderous. All of this is backed up and documented. I have a list here of all of the grievances that myself has faced. One, they have no meetings. I have them on tape requesting admitting that they don't pay HOA themselves. The HOA president actually owes $250,000 herself, and her justification is, well, I'm the HOA president and I cut the grass. And I'm like, we need, the roof is falling apart. I've used local politicians in the City Council of Atlanta to do what they can that's in their purview using code enforcement against them. There's open sewers, live electrical wires open to anyone. And since I only have 2 minutes, I'm going to just go down the quick list of grievances. We have no HOA meetings. There's no elections. I actually secured an attorney, which was very hard to find and expensive. They don't even have board meetings, which they admitted to. Georgia law entitles any homeowner in an HOA to inspect the records. Their lawyer told my attorney that we would get you the records. We set up a date and time. They were no-show twice. And to this day, we still don't have a budget. They are also on tape admitting that HOA money is going into private bank accounts, which I've contacted APD Major Fraud Unit. Nothing has come from that. And then also, properties are being held hostage, so people aren't getting fines and people aren't being foreclosed on. But what's happening is when you go to pay your HOA, your check is returned. They then ask you to pay an HOA fee in cash, which I've refused to do. Also, the community is rampant with crime. There's been several APD raids. And this is very easily, these issues to me, it's very black and white. It's a complicated issue overall, but I feel like the specific issues with this HOA is easily resolvable by oversight. And then really quickly, and I'll wrap this up, I have a website and an ongoing lawsuit right now that's sitting with Judge Paige Reese Whitaker in Fulton County Superior Court. That lawsuit when it's all said and done, it's probably going to be past $30,000. I'm not rich. I don't even consider myself middle class. I actually lost my job last year and really extremely tapped out with this because I'm fronting the bill for an issue that I think is just. People told me to cut, run. I face death threats like some of these other people as well. I have a tenant right now who's being harassed by local thugs sent by this HOA president. She shouldn't even be on the board once again because our bylaws, if you owe fees, you shouldn't even be on the board. And unfortunately, one of the responses her attorney gave our attorney is that no one could vote. I don't have elections because everyone owes an HOA fee. And the reason why is she is turning down valid payment. And this is the last thing, and I'll close out with this. My website is basically mirroring the 205-page lawsuit that I currently have, which, by the way, they haven't responded. And the HOA headquarters is an abandoned house in a different county. And we have no property management. All right, so really quickly, I have documented that they are violating Georgia Code 16-82. Potentially, that's theft by conversion with the money going into private bank accounts. They're also cancel our insurance, which is required under Georgia Statute 44-3-107. It's a condo community. If something happens, we have shared property. It's not like the owners can go out and fix, things that are common, like a general pipe that's shared between all the units. Of course, you have your own personal insurance, which is for your actual unit, not the entire building if something happens. The other thing that I have on my list is Georgia Code State Statute 14-3-1602, which is they're illegally withholding the records. I have been an owner for 3 years. I haven't seen a single record, not a budget, not a meeting, not a minute. And then I will leave off the rest of the stuff because that's our own bylaws that they're violating, and hopefully within a week or two we'll be eligible for default judgment. But this has cost us about $30,000, and I footed most of that bill myself. So.
Okay, I do want to make a quick comment because we've heard it from the Ms. Thomas as well, and you as well, Mr. Shepard, on the meetings. One thing that we did add in HB 220, again, we're going to have to go back and make sure we got it right. On lines 115 of that bill, it says, in the event an association fails to hold an annual meeting on or before the last day of the association's fiscal year, such meetings may be called by the holder of at least 5% of the voting power of the association.
Yep.
So, so we've guaranteed your voting rights, and we've guaranteed that you're going to have that 5% of y'all can have a meeting, unless the bylaws call for more percentage, if they specifically say it, but they can't go over 25% in their bylaws. So just, that's in there. It can be tweaked. We need to look at it, but just letting you know, we did address it. So if you've got an attorney, make sure he's aware of that. And if there's, again, this was all done kind of last minute.
Okay.
So this is one of the bills we're going to be looking at to make sure we know the intent was right. We got to make sure we got the words on paper to match it, what the intent was.
Quick response to that.
But it was to fix those things that you're discussing.
I just took that down to look at that. I appreciate that. With regard to the 5%, that's just jogged my memory on something else. So in, I guess, the state of Georgia, you need 5% to launch what's a derivative action, which that lawsuit is. We actually did call our own special meeting per our bylaws, had a really great turnout. We actually met a quorum, and they basically responded with, well, we don't care. And I still had to launch that lawsuit, which is why I don't have a whole list of fixes, but one general suggestion is, and I know a lot of people who don't like this because they think government overreach, but we have insurance regulatory agencies, we have financial regulatory agencies. A lot of people think, well, if you have an issue, well, take it up with the board or the property management, but that often goes left, and what does that leave you with? There's no intermediary between an HOA issue and the judicial branch. Mm-hmm. There's nothing executive, administrative, and so I basically bring that point up to say, even if that was on the law, I could be missing something, but even if that was on the law, we've met that, they can't deny it our right. Our particular HOA will say, go kick rocks, and then we launch a lawsuit.
There's no enforcement arm.
There you go.
Gotcha.
Yeah, and
that's
we
fair.
actually voted her out, but she refuses to leave, which is one of the main reasons we have this lawsuit. And then
Okay.
So I'll leave you with that. Thank you
All
for your
right,
time.
thank you very
Appreciate
much.
it.
Appreciate it. Gentleman in the tie. Well, I don't have his name.
Oh, Mr. Harris, Richard Harris. I'm with Magnolia
Richard
Walk,
Harris.
Phase 3. It's a community located in South Fulton, between Buffington Road and Red Oak. It's in the Red Oak community. Well, Buffington Road and Roosevelt Highway in the Red Oak community. I'm here due to being invited here by one of the senators, Representative Thomas, regarding some issues with that community. I'm going to go over some of the issues that we have and to shorten time. Board members not paying HOA fees and continue to work as officers. These board members are property managers paying the HOA officers for services not rendered. An example, pool gates supposed to be purchased. Board member tells the HOA that the two board members tell the HOA that the gates have been purchased. The gates purchased and then sent back, but they keep the money. Another instance, cameras are supposed to be installed. Board member tells the HOA that this unapproved vendor has already put in the camera systems, or about to finish up putting in the camera systems. HOA paid this board member reimbursement for what he's supposed to have paid this unapproved shell vendor who we don't know who it is. And that board member still has the money. Board member's not paid his dues, yet he still functions on the board. Money's being paid to companies not performing work and leaving without rendering the services, about 16 grand that they walked off with. These are some of the issues that we're having. Attorneys being aware of the issues and not freezing accounts. Board members the community is attempting to call a meeting. Attorneys suggesting that these members should not call the meeting because they didn't follow the proper protocol, which was followed. Attorney said that the protocol was followed, then turns back the day before the meeting, 24 hours before the meeting, said they weren't followed, but have an email stating that they were followed. So these are the kind of issues that communities are having with board members. They're having them with these law firms. A quick issue that got me involved in this, I moved into a house that after I signed the contract, everything went fine. I stayed there for 6 months, pulled my Corvette out the driveway. The next month, I have a fine saying $1,700 for a tree that was burned up in the yard. I got that straightened out by, I can't explain to you why I got that straightened out, but I got it straightened out. Planting a tree was $100. Well, the tree that was previously there had been struck by lightning and died. So these are the issues that we're having with boards, we're having with property management agents, we're having with collection agencies who are filing liens on people's homes, and they haven't gone to court like was said earlier. I don't have any suggestions for you right now. We're going to be hiring attorneys and filing class action lawsuits, and hopefully we can get together with other subdivisions to file class action lawsuits against some of these HOAs and some of these property management companies and some of these attorney firms. So if I can get some of your numbers, members of the community, so you can join us in doing this. Thank you.
Thank you, Mr. Hare. Appreciate your time. Was there anybody else that wanted to say a quick word? No, David, I'm sorry, man, we're kind of out of town. Was there anybody that has not been heard? Okay. All right. So, all right, with that being said, here's where we're at. So next meeting, we're going to be October 22nd.
October 22nd.
We'll be right back in here. And we're actually going to be hearing from some of the management companies, and we'll have some experts in here that are, going to be kind of talking about best practices. I think we've heard some very good examples today of worst practices. So we're trying to figure out what works, what doesn't work. Mr. Shepard brought up a excellent point, something I hadn't even really thought of, in the HOA setting. You have a legislative branch and you have a judicial branch, but you don't have that enforcement arm of the executive branch. And I think that is a wonderful point, and really sums up, a big problem. And so that's what we've got to figure out, is who is going to be that executive branch of this type of setup. Because this is just essentially local government. And just because it's local government and it's community run doesn't mean people lose their constitutional rights. And that's what we're here to prevent. We all swore an oath to protect it, and that is what we're going to do. All right, so with that being said, yes, ma'am.
Mr. Chairman, I saw something maybe about 4 weeks ago on the news about the FBI here investigating management companies of HOAs, and because they all were part of the same group bought by a corporation. And so I need to make sure that we get that report and look at that as well, to see if we have foreign entities that have come in here and bought up, that have the management companies are making the HOAs take people's property or do some of these things that we heard happening now. So I want to get that report, but it's the FBI.
All right, sounds like you volunteered for that. So if you will grab that,
I will.
track that down, and distribute. If you want to get it to us, we can distribute it to the committee.
Okay.
Thank you.
Thank you.
All right, meeting adjourned. Thank y'all.
Thank you.